whatever those are. Then somebody said, wait a minute, you're now taking adverse action against me. Losing my livelihood or my, or a violation, not of a rule, but of a learning objective that have gone through the process to establish those learning objectives. I'm not saying that's a good idea. I'm not advocating it. I'm just wondering if this.
Could that happen now though?
Yeah,
It could, but.
and I see what you're saying, but I don't think that that's a problem because the legislature had directed the post board to make the learning objectives. And then the rule and statute both say then the schools will teach the learning objectives promulgated by the board. So I see what you're saying, that the learning objectives themselves don't go through an official rulemaking process. But I think there's enough safeguards and rails there that say that the post board has the statutory authority to do this. And in fact, we as the legislature expect the post board to develop these learning objectives and keep them. And I think if they wanted them to be part of rule, then that directive would have been put in statute that they'll be promulgated through the official
And
rulemaking process.
I don't disagree with that.
Yeah.
Maybe if we want to anticipate some knucklehead like me raising that at the time of sonar, that the explanation you just articulated might be worth putting in sonar. But that's, yeah, I'm not.
Yeah. Because otherwise, the implication is that we have to put every single learning objective in rule.
Right, and then when the world changes because of this, that, or the other thing,
Yeah.
you don't want to do that.
No.
I absolutely understand why you
Yeah.
don't.
Okay.
So can I ask a silly question? Probably a silly question. But
Go ahead.
these are definitions for pre-service. So
Yes.
why is law enforcement agency in there that has nothing to do with pre-service?
Well,
Because these are definitions for. the
definitions
entire
are for
chapter.
everything in chapter 67.
All right.
Yeah.
That's why I said it was a silly question.
No, we're not trying to slide in law enforcement agency academies.
Well, there was other ones I had Xed in here too that I asked.
Michelle?
Yes, one thing you might want to add is a definition for adjunct. You know, you've got in 0300 subpart 8A, you've got something about adjunct instructors, blah, blah, blah. But then there's no definition for adjunct in this definition section. But you do have a definition for guest lecturer. So that's what caught my attention. It's a minor point, but might be a good idea.
Does anybody in the room or online, do the schools use the same definition for an adjunct? Because that was actually a thought I had as well, but I didn't know if there was a universal definition and we didn't want staff maybe classified a different way who are used as an adjunct to then all of a sudden be ineligible to teach in the program or something because the school's definition doesn't meet the definition. So that's what I was afraid of. So that, I'm glad you brought that up. So now we could flush that out.
We were just talking over here. We might need to look into that because
Okay.
it might also depend on the contract, because all of our schools are not under the same labor contract.
Okay.
Because the universities have a different one than the,
Yeah.
but that's something we could look into and send and see if there's some consistency there.
And then also the private versus the public schools
Yeah.
have different rules as well.
Okay.
I mean, really the distinction, I think, the spirit of what Michelle's getting at is the distinction between a full-time permanent employee of the institution versus somebody who's hired to teach that specific class. And so there's probably some language there that needs fleshing out.
The term contractor used or not, or is that?
No, not necessarily. I mean, adjuncts are usually just not full-time
Right.
instructors, but it'd be more than a guest lecturer because adjunct instructors are responsible for their curriculum
Right.
delivery and development for their course.
But the instructor of record is probably maybe the language we're sort of getting at. It's like the instructor of record for the course, something like that.
You raise a great point. Depending on, like when I teach for SPS Northwestern University, depending on who even my boss is talking to, sometimes she'll call me an instructor, sometimes she'll call me adjunct. So, and she uses, depending on, it's like, I don't know the academic.
Yeah, we use community faculty at Metro State for adjunct. So there are different languages, but I think what the essence of the idea is, who, the buck stops with somebody in that classroom, right? And I think it's the instructor of record is the language.
I think that's actually covered under your definition of instructor, because you don't, the definition doesn't distinguish between full-time or adjunct. So
Exactly.
I think that covers the
Yeah.
definition there.
Yeah.
I'm trying to think of where adjunct.
So you're
is.
thinking, Pat, we might not need a formal definition?
Well, I think we gotta
Because the
figure
other
out-
thing is I don't want to take, like, that's a discretion I don't necessarily want to take away from the schools either in
Yeah.
deciding who is an adjunct and how to use that, because you guys have talked in this room previously about how hard it is to find staff sometimes. So, you know, if your school says technically per contract adjuncts teach X amount of credits a semester or whatever, but this person is teaching half-time that, and it's just something you guys worked out. Well, now if they're not meeting our definition that we created, like, I don't want to create additional problems in trying to find staff. So I don't know if that's just something we stay away from for now. Like, yeah, by all means, look into it further and let me know what you guys think after today. But I don't have any issue staying away from that for now. And if that's something we have to come back and put in later too, that's fine.
Well, and we did hear also from a PPOE coordinator that they didn't believe that all the schools or all of them in state required, for example, adult learning or program instruction development courses from their adjuncts. So we just leave it under instructor, and you know what I'm saying? We kind of have to separate those out because we didn't want to do that necessarily to require that level. So I think we even added the term
Yeah.
full-time
Yep.
in there to try and differentiate. So I think it's still valuable to look at a good definition for an adjunct or temporary or part-time, whatever you want to call it.
Actually, you could probably just distinguish it in a definition, because I mean, we have it distinguished in rules. An adjunct instructor is someone who provides provides teaching within the curriculum, but is not a full-time employee of the institution. That way, we're not worried about credits and all that kind of stuff. I think that would cover almost anybody's definition of an adjunct at that point.
Does that then distinguish adjunct enough from guest lecturer?
I think so.
Yeah, I think
And I
so.
like it because it does help to define that, you know, what that person, the very part-time person has to do in terms of their criteria versus a full-time instructor.
Can we say a full-time faculty member? That is not a full-time faculty?
Changes, they're looking okay.
Yeah.
Okay. Okay, Melanie, so we have guest lecturers, means a person who is invited by the instructor to occasionally teach in a pre-service or board-approved continuing education course. Would this then be by the instructor or adjunct? Because an adjunct is in
Yeah,
charge of their own class, right?
But an instructor below, it doesn't differentiate between full-time and adjunct, so you could just leave instructor.
Okay.
is occasionally the right word, or is it more like ad hoc? Or maybe I'll look to my lawyer over here.
I think occasionally it works, because if you bring in a guest lecturer to cover, I don't know, like maybe building searches or something, they have an
Yeah,
expertise, they might be there a couple of days. Or they, yeah, I think that occasionally would work.
We have school, so this is the 0501 change that this group made. So it's a post-secondary institution, which is accredited by a federally recognized accrediting agency or recognized as meeting accreditation by a current member of the National Association of Credential Evaluation Services. The school must be authorized to award degrees. Post-secondary degree and academic degree awarded by school, same change that this group made originally. And then we have, these are new. Since this group last worked on this. So in order to, I guess, hone in on what the requirements are gonna be for skills versus academic portions, we have definitions for primary certified school and secondary certified school. So primary certified school means the certified school a student enrolls with and begins the peace officer pre-service program. A secondary certified school is going to mean the certified school a student enrolls with to complete the psychomotor skills component of the peace officer pre-service program. So this is like somebody starts with Mankato and then goes elsewhere to do the skills component. You are the primary school.
Sign on.
Yeah, so that's the sign off school. Okay, so then maybe we need to add on secondary certified school at the very end, if different than the primary certified school.
Good.
Because if they go to Hennepin Tech, they're the primary, and it doesn't matter if.
Right,
Yeah.
yeah, okay,
That's right.
There we go, that'll differentiate it then.
Yeah.
okay. Anything else on those two, James? Wheels are turning.
Does it matter? Does it
Go ahead.
matter at all how long they've been out of that school?
Are you talking when somebody comes back 30 years later wanting to be a cop? We fixed that later on.
Okay, very good. Thank you.
Okay, all right.
My wheels are turning more on 32 and 33.
Okay,
And I'm genuinely just asking the question to sort of see where we're at with this. So when I look at the post-learning objectives, and I think about the structure of the way in which many of our programs are currently built, I think there's aspects of category 3 that probably the theory schools are maybe teaching. Is that fair to say?
It is.
In the current curriculum. So I guess my question is, will this now be an enforced hard and fast rule that the academic component really only comprises 1 and 2, and skills is going to comprise 3 and 4? And that might mean, and the administration of this, that skills is going to get bigger, right? And academic might get a little smaller, maybe, right? But that will be a clear, hard and fast distinction now. And I'm not saying that's necessarily a bad thing. I'm literally just asking the question, because if it's in the rule and it's spelled out that way, that makes it pretty clear that the academic schools have to stay in their lane, if you get what I mean.
So just for context and to your point, as we were going through this after the board's decision to say, okay, go ahead and work on 3 and 4, we had to find a way to, and again, to Rick's point from earlier, to really put in rule that there is a distinction.
Exactly.
Yeah, between the 4 components. Because we've all, up to this point, played in the sandbox that there is a distinction between 1 and 2 and 3 and 4. So now we're just memorializing it in rule. Now that said, to your question, it seems to me, because I think there's a provision in here that says you can teach additional things over and
Sure.
above. So I don't think that prevents an academic school from covering some of the 3 and 4, just knowing that the school that does 3 and 4 is also responsible and is going to cover that. So it's not an exclusion versus, you know what I'm saying?
Yeah.
We had to find some way to, because otherwise, and again, this is probably where Rick thinks a lot of the area he operates, we're engaged in unpromulgated rulemaking. We start talking about 3 and 4, 1 and 2 and all that if we don't define it. You know, we've been saying psychomotor skills for how many years and it's never been defined anywhere.
Well, under some,
So-
if an institution wants to do 1, 2, 3, 4, doesn't mandate sequence.
Correct.
1, 2, 3, 4. So they could do traffic stops, along at the same time they're teaching constitutional law. if they
But
want.
that's not gonna absolve under this because there is a distinction now. That would not absolve Tom, for example, from having to cover that also in 3 and 4 because he's responsible.
If a
Right,
student,
3 and
if
4.
a student doesn't go to a place that does all 4, I agree. Yeah.
And that's the thing. So 3 and 4 will be standardized. And so I suspect when this eventually plays out, skills, 3 and 4, is probably going to end up being bigger than it currently is, right? I can't see it being done in that same time period and same structure, right?
Correct.
Yeah.
Yep.
Yeah.
And we're working on the details.
And
of
probably the
that
same
work.
credit load.
Yeah.
Yeah.
And in the new copy, everybody that I sent out this morning of 0300, the subpart 3 that we put back in is where it goes back to saying that schools can teach above and beyond
Yeah.
the minimum requirement, so that then plays into academic schools, academic components that can cover more than 1 and 2. But then it
Yes.
has to be covered then under the standard portion again in the written form as.
Yeah.
Go ahead,
But I'm
Michelle.
thinking more from-
Just a minor point, but you're, here we're talking about categories 1, 2, 3, and 4. But I think in Rule 0300, it's called A, B, C, and D. Am I wrong?
You're right, but that's just how rules are drafted, Michelle. So A, B, C, D isn't necessarily the like name of those things. It's just how rule segments work, if that makes sense.
Well, I've been just saying, I was thinking it should be named the same thing as in this part as it's called in the other parts, but you know, you guys know what you're doing. So, okay.
Yeah, no, I see what you're saying, but yeah, we can't. And when you look at the actual learning objectives packet, they're labeled exactly how they are in the definition as category 1, 2, 3, 4. So,
I guess to Michelle's point.
Yeah.
And maybe this is a good one for you. I mean, we could, we're not at 300 yet, but when we get there, we could say relate to the following components. So it is consistent through all the different rules. And then we say, component, you know, instead of, it could be labeled A, B,
we
and
could
C.
put it in the text, but yeah, we can't
The
change
text,
A, B,
yeah, I'm
C,
saying in the
D.
text.
Yeah,
Okay,
yep, we can
all
do
right,
that.
Yep, never mind.
Can I ask another question related to this? This all seems fine. I think we're in agreement. Is there a chance in the process of standardizing skills that the learning objectives get rewritten and then you add additional categories? And then the rule would need to be changed again because there's now a category 5 that's been determined to be the case. Does that make sense?
It does. I think I'll field that one since I've been talking to KU, who's the one who builds all this stuff or we're working on a contract with. And theoretically, it could happen. I don't necessarily think that's going to be an issue. I mean, it's unknown. We don't know for sure
Yeah.
what the end product's going to look like, but I think everything we've been told is that our existing learning objectives and the 4 components are inclusive and broad enough to generally cover what is required of peace officers, right? So I would suspect if there's additions, and I'm sure there will be additions built out, but they'll fall under one of these categories. Not to say it couldn't end up with a component 5. I just think that these are broad enough that my sense is that wouldn't happen. And if it did, well, then we have to change rule. So,
I just have a minor point on 32 and 33. I think it would make sense if it says the published categories 1 and 2 instead of just categories 3 and 4. Because sometimes we're in the flux of changing, and if we're enforcing a rule, it should be the published version at the time. Thank you.
And I'll just say, is published even the right word? I agree with the spirit of that, but is it more like the approved or the?
how about board approved?
Yeah, whatever.
Yeah, well,
So
yeah, but
whatever
I think you're
is-
right. I think
Well,
you're
not
right.
only board approved, but it has to be.
It has to be like,
available
it has to be like public, right? Yeah.
You have it in rule two, I think it's in 03, where any changes that the board has to give you guys.
Right.
A reasonable period of time to implement.
Yeah,
That's right.
So, yeah, so I
I-
think
I
that
just-
we
that
can
if-
keep the board approved if that works for you.
Yeah,
Pat,
that's fine.
But then I think that other piece catches what you're getting at, that we can't hold you accountable to something that we haven't
Yeah,
given you
that's
time to
fine.
comply
Yeah.
with.
Or it's gotta be the spot at the time that the rule is being enforced.
Yeah, it's like the official categories
Yeah.
1 and 2, right?
Right.
Yeah.
Not that I think any of us should have problems and violate that, but if we do, it's nice to have that
Well, I
flag.
think you're right.
All right, so we have support 34, pre-service advisory committee, invited, whatever means, a standing committee of various professional subject matter experts and stakeholders that advise and aid the board in the development and updating of pre-service program topics and learning objectives.
I don't think we need the word various in there, but otherwise the rest of it looks fine.
Then adjunct instructor is the one that we just did. So any other comments on 0100?
Yes,
Go ahead, Rick.
subpart 9A conviction. The chief, that's gonna become even more important when we get into 0300. See, Eric's out laughing. He knows
I know where, I know
He knows where I'm going with this. I'm gonna do my bugaboo expungements. 609A03 already, and I just did a background class again a couple weeks ago. Law enforcement agencies, because of the massive hug-a-thug expansion of expungements, are making it harder and harder to find criminal history records. 609A03 specifically says they are available, convictions are available for employment with a law enforcement agency, so those can be found. Schools are not a law enforcement agency, which means our definition says a stay of adjudication of a disqualified offense. You get a felony stay of adjudication. You are disqualified from taking a peace officer license. Our rule say you don't get into school, you don't get into a program if you are determined to be convicted of a disqualifying offense. Yet higher ed is going to have absolutely no legal way to access those records. And higher ed's even in worse shape. Higher ed won't even be able to get a disqualifying felony conviction. You could have somebody that's convicted of selling drugs, which is a crime of violence. They can't lawfully possess a gun. They'll never become a peace officer. But if they went to court and got that sealed, higher ed will never legally be able to find out it exists. So they're going to be bringing people in that once they actually go through the entire program, in my example, they shouldn't even be possessing firearms. So higher ed is aiding and abetting federal and state felonies, but giving them a gun to use. But above and beyond that, we have those people now will be subject to a criminal history record check. That conviction will be found when they get applied to the Washington County Sheriff's Office. They're going to be found to be ineligible to qualify for a peace officer license. They're going to be rejected, and everybody's going to go, "What the hell? We just spent." Students going to say, "I spent X amount, 25, whatever $1,000." Nobody. I obviously am help. I'm qualified. You can just see the chaos. So my thought to minimize that impact, ideal world would be to change 609A, chapter 609A. We can't do that.
Right.
But since we already say under the definition of conviction whether or not there's a stay of adjudication, I think we should consider adding whether or not the record has been sealed or expunged. That opens the door. If I have to, if people have to start applying for court orders, and a judge says, "What's your legal authority for me to issue this order?" They can say, "Post board rule, blah blah blah." So this is only going to get worse because the school will presumably have a person sign an informed consent, so they'll get clean slate expungements because that's private data, and they'll get the drug expungements, and because that's also classified as private data. For the court ordered expungements, schools won't get it even with a conviction. And so I think there's going to be a huge disconnect between expungement and this whole process. And we'll at least try and fix it.
Can you give her that language that you just said?
Uh,
The part about.
Sure,
regardless
whether or
of-
not adjudication of guilt is withheld or not entered, and whether or not the record is sealed or expunged.
It'll also protect the schools, because I mean, if we ask and the student doesn't tell us, and we have in there that even if you had expunged or sealed, and we need to have access to that, that does protect us.
So,
Okay, so pause.
Yeah.
I'm sorry. Go again, Rick.
Okay, and whether or not the record has been sealed or expunged.
Okay, so did I get it on the screen?
Oh, there's a vision test as part of this.
Can I ask a question? Just a
Yeah, go
clarifying
ahead,
question,
Michelle.
because I
Yep,
think
go ahead.
Rick's point is very good. So would that information come out through the BCA background check?
Not right now, the BCA won't be allowed to disclose it. It would be a
Oh,
violation.
okay. Thank you
They
for that
can't-
clarification.
They can't tell anybody it even exists. They can't even give, if it's by court order, they can't even give the person who got
This is also the student.
case
has to
sealed.
disclose it as part of that.
a copy of their own record.
As part of their.
oh, sorry.
So we can do this for now. I just want to give everybody the caveat that this 9A affects a lot. Specifically our standards coordinators, it affects testing, all of that. And we've actually been going around and round with the attorneys on a separate issue regarding this definition. So I can't make any promises as to whether or not this adjustment or any of the adjustments on 9A currently are gonna stay. But I can bring up this specific provision and see what the attorneys with the AG's office think. But
It's gonna
this
have-
has just been causing a lot of issues in a lot of different areas, so I just want to be upfront.
Impact pre-selection standards, going to impact grounds, all the new mandates that went into effect in June 2023. Absolutely will have a huge impact on it, but the policymakers have to finally decide. Are we going to, so-called, clean up the profession of law enforcement and get the bad actors out of there? Or are we going to let convicted felons or people who should have been convicted, who were charged, are we going to let felons and other domestic assaulters who are able to get their records in, are we going to let them in the profession? So which is more important? The clean slate, yay, rah, rah, forgive everybody expungement? You can tell my perspective on this, or actually cleaning up the profession.
So,
And
go ahead.
it's already putting my people, my sheriffs and chiefs in a bind because they're going, we're trying to do everything we can to comply with post-grafting, make sure that we're not hiring the bad people. And yet the legislature, nobody's blaming post for this. The legislature is making it increasingly difficult for us to do, on the other hand, what they're telling us to do. So any pain relief at all, but you're absolutely right. It is going to have a ripple effect to more than just what we're here talking about with the training. So it will have a huge impact all throughout the system. Standards of conduct, revocations for, I got to stay on adjudication, you can't revoke my license. Right now, we've got that covered, but well, I got that record sealed, can't. And by using the word sealed funds, we cover both Minnesota, like that incident that happened, and we know that publicity, the person who comes to Minneapolis, right? With a criminal sexual
Out east.
conduct from out east and gets hired, well, everybody's now finger pointing. This opens the door to start to address that.
So if I could add a little color to that, or a little context probably is a better term. So a couple of things are going on. One, and we haven't gotten through 0300. Again, part of this struggle to comply with what the board wanted us to do in terms of 3 and 4 versus 1 and 2. You'll see that we put back in the long established rule that applies to all schools because we know there are limitations on what you can get. There's limitations on what we can get. Now, I have another piece of information on that, but so we put the old rule back in, again, recognizing the I would say focus or the guardrails that the board put on as far as we're just dealing with 3 and 4. So what I'm getting at is with regard to background and entry standards, we put in as a group, we put in some pretty beefy, had to meet the minimum selection standards and whatnot. Now, you brought that up and I had discussions with the AG's office, and we also question whether we have the ability or the authority to do that. So you're going to see that 1 and 2 definitely revert back. Now we have a much stronger case when it comes to 3 and 4. And then within 3 and 4, it's a requirement that the applicant submit all the consent forms to allow all that information to be shared, not only with the schools, but with the board. So we'll see when we get to that point, Rick, if that covers the concern you had. And then generally what I'll say is there is actually, this has been going on since I came to post, but actually with, depending on, again, government shutdown, all the garbage going on at the national level, there is a bill, bipartisan bill, sponsored and on the table that would recognize licensing boards as having the ability to see criminal history, CJIS information for applicants to law enforcement positions, which we've never had. Other states found ways around it. But regardless, if that goes through, which and I'm talking from an IADLA standpoint, we're hopeful that's going to happen. There may be other mechanisms by which Post, now with this new authority, can screen those and actually absolve the schools of needing to do that. But again, we have this kind of in Minnesota, because of the way we're set up, we have this conflation between degree programs and peace officer training programs. That causes a little bit of grief because of the issues of federal law regarding access to education and all that kind of stuff, where you have a clear, this program, whatever it is, exists purely and only for licensure certification to become a sworn officer. There's, as I understand, case law that easily defends your ability to restrict access to that program based on clear criteria. But because we have this kind of mix, that's where it kind of crosses the wire. Anyway, just contextual for everybody to know. I'm still tracking it. We'll see if it happens. But when we get into 0300, we tried to address that.
Say,
a little
Eric.
bit. Yeah.
I have a question. So if you have skills that is attached to a program planner, doesn't that give us authority if somebody doesn't make the MMPI standard or background? So just what we do, and our policies have been through the AG's office. They have a right to an education, so we transfer them to the AA program and they use our intro classes as general electives. So that way we're in compliance. Does that make sense?
Yeah, so that's part of the reason that as we looked at the comments Rick had and we looked at and talked to the AG, that's part of the reason we brought back the existing rule with regard to entry. So what you're doing now would continue. And
Great.
under the existing rule, if they don't do, as if they don't pass MMPI, well, that clearly, presents potentially a danger to others, or however that will remain. We think we found a good middle position where we made it more clear with regard to, since we're going to separate out 3 and 4, that 3 and 4 is easily defensible as directly. The only reason you go to 3 and 4 is not to become a lawyer, it's to become a cop, period, full stop.
Right. And I do it at the beginning,
Yeah.
because I don't want people wasting their money and they
Here's
find
the
out.
thing. Yeah, here's the thing though, Gay, so one of the things we ran into, and I think to Rick's point earlier, if you were to deny, this is what we were doing when we wrote it originally. If
Okay,
you deny a person, for example, you use the minimum selection standards, and you deny someone access to your 2 or 4 year degree program because they don't have a driver's license, a valid driver's license, that's not defensible because theoretically, sometime in that next 2 to 4 years, they could easily get the driver's license and come into compliance.
yeah, we don't
So-
do that till skills though.
That's my point. Now we're
Yeah.
actually, we're actually codifying it, that skills is where it matters, not.
Or the big, or the related issue is, what if they never are gonna get a driver's license? The reason they don't have one is because they have a significant disability, which means they'll probably else will never get the criteria to be a peace officer. But that's separate than an education. I can still.
Yeah.
I learn, and under the American Disabilities Act, you're excluding me from sitting in a classroom all day because I don't have a driver's license. How is that consistent with federal law? I think rules probably, from the school's perspective, it's probably good work for some private detective firms, because they're probably gonna be doing background investigations almost at the police level before some people get into classes. Or at least
To 3 and 4, at least.
for 3 or 4, yeah.
So on that note, you guys, how about we just jump into the whole 300 rather than talking it, because we haven't even looked at what's in here and how we've adjusted it. And we've got a lot to get through yet in the next hour and 10 minutes. So, I just am looking for a stomach check. 0100, is anybody like strongly against the changes now and how 0100 sits? People online, raise your hand if you hate it or hate something in it. Let me know. Otherwise, I'm gonna write it down that we have consensus. Good with 01? Don't be shy, don't be bashful. Okay. So then 0300, subpart 1 is the same as how this group drafted it, with the exception, well, it's not the same, we tweaked it. So I put in the as category 1, as category 2. Michelle, as you suggested, I see your hand is up, go ahead.
Oh, shoot. Come on. Sorry, I'm sorry. I was having trouble with my phone. The only thing, yeah, no, these are fine like as is. I was waiting until we get down to the part about the reasonable notice.
Okay, give me 1 second and I'll come back to you. Okay, so we have the peace officer, pre-service, POP, whatever, shall teach the learning objectives set by the board as prescribed. The learning objectives will relate to the following categories. And then we consolidated this down to just the 4 overall categories. And then we have the structure of the psychomotor skills component will be provided by the board to certified schools. When the learning objectives are revised by the board must give the certified schools a reasonable period of time to adopt and implement the changes. Go ahead, Michelle.
So 2 thoughts. One is the way that it's structured right now. It makes it look like that the reasonable changes will only be for any kind of learning objectives revised in the psychomotor section. So that's the first thing. The second thing is, I think we should probably define reasonable period of time to be
Yeah.
something like months or something, because when you have a curriculum change, you have to like go through and rewrite your course materials and do all this stuff. I think we have to give these schools some real time, and I think reasonable time is too vague.
And
No,
I'll let Pat answer.
we need to leave it reasonable period of time, because depending on when the change comes through, if it's like after a curriculum cycle in a school, it could be another year before we get into that. So a reasonable time, some might be able to implement it within weeks, others might need up to 2 years to do it, depending on what kind of change it is.
Yeah.
And I will say that I think that that's one area where the board does a really good job communicating with the schools.
Yeah.
Saying, hey, how much time do you think you're going to need?
Yeah.
And then is it like a memo, Pat, that goes out, or some kind of stipulation from the board that says by this date, after conferring with you guys, you will implement these changes?
Yeah,
So,
exactly. And curriculum changes go through a variety of levels, all the way up into system levels. And for private schools, the same thing. They go up into system and governing board levels. So leaving reasonable period of time, I think, gives the board enough leeway, but also provides enough rails on there.
But do you want to use the structure or content?
Oh, yeah, I think I have a concern with the word structure as well.
Structured is all of a sudden the legislature passes a law on banning chokeholds. That's not structure, but that's a really important substantive thing they would have to immediately pivot to start teaching. So,
Okay, so what word do you
Yeah,
want?
what would be a better term?
well, I think content, these are the professionals. I'll defer to the folks here.
Well, I think we've actually had quite a bit of discussion about this before, about the correct term for this.
Yeah, I
I
think,
thought we came up with like minimum instructional standards or something like that. I don't remember.
We came
what
up with
it
a
was.
curriculum. We decided that was.
Well, then curriculum was too vague.
Yeah.
I mean, curriculum was
Yeah.
because really what the board is gonna say is, we expect you to do this in category 3 and 4.
Yeah.
Right? And
well, I think because it's gonna be standardized.
Yeah, so it's gonna.
They're gonna
be-
tell you like, you need to do this and how to do it and when to do it and everything else. It's gonna be it's gonna be a curriculum.
so those teaching 3 and 4 won't have a chance to do more than that? So if I'm
No.
teaching,
No.
so if we're teaching, say category 3 and we're doing scenarios at Mankato, and we want to make sure we include an element for rural policing about dealing with cows, we won't be able to
You
do
could,
that.
no, you could still do that.
Okay, so here, the structure then is the minimum.
Right, there'll be a minimum standard, a standardized standard. That doesn't even make
I know,
sense.
see, that's a.
You
it's a
know what
term.
I'm saying?
Yeah,
A
yeah,
consistent
yeah.
standard.
Yeah.
for-
Yeah.
See, like right now in the skill schools, all over the map.
Right.
On hours and how much time
Yeah.
is spent and blah, blah, blah. So we're gonna set a minimum baseline, but again, I think, and again, I'm just kind of predicting
Right.
and putting my Nostradamus hat on once this gets developed. We'll include something along the lines of, but that'll be a business decision by the school. If you want to do something over and above
Yeah.
because you're catering to a particular
Yeah.
customer base.
So I think to protect the post board and the schools, we should come up with the correct phrase here about the minimum standards. So that if a school does go above that and makes that business decision, that it's okay, but it's acknowledging that they have to do the minimum that was standardized for categories 3 and 4.
To your phrase that, what, instead of structure, what the minimum standards of cycle, would that cover it? Because what if everybody says, hey, cow, dealing with cows is a really good idea. They're running around I-94 downtown St. Paul. So if,
I think if you did
Plus, we
minimum
use a-
standards, you'd still be able to provide that structure you're looking for, Eric, and the schools would have that to go off of. And then if they did make the business decision, I want to add 2 more hours to deal with something, they're still meeting the board's expectations,
Yep.
but then they're also serving their students.
Because the minimum standard might be, you have to do this for 10 hours, right?
Right,
And you've
yeah.
determined, we're gonna do it for 11.
Right.
The minimum is 10, so you're still in compliance. So I think that's right. But I do also agree with what Michelle said, which is the wording of this should be flipped. The ordering of the 2 sentences, which is, so it should begin with, when the learning objectives are revised by the board shall give certified schools. And then it should say psychomotor skills, because the learning objectives apply to everybody. Whereas the way it's written right now, it sounds like it only applies to skills.
Yeah, I would even make that a separate paragraph and make that second sentence its own paragraph. So I realize it's not proper to have a 1 sentence paragraph, whatever.
That Paragraph wise, I'm gonna leave that how it is, because that's how rules are, but then I can touch base with the revisor's office and see how we would go about doing that. 'Cause if we do that, then I'm gonna have to change how all of this is structured. If that makes sense.
I think the flip, that makes
I
more
think the
sense.
flip
yeah.
is it does.
Okay.
my only,
That's
but
fine.
my only
It's a minor
addressing the
point.
motor skills, does that
You're okay,
apply
Michelle.
for part 1 and 2? That reasonable notice isn't necessary when it changes? Why are we saying we are only going to give the schools reasonable notice for changing psychomotor skills?
No,
No,
I think we
with
just
the-
addressed that.
Yeah. with changing it.
Oh, no, I get that part.
That's the only reason I thought it should be 2 paragraphs, because it makes it clear that it applies to everything.
How about this?
I have it as when any of the
When
learning
any of the-
objective categories are revised by the board must give certified schools a reasonable period of time to adopt and implement the changes.
There you go.
Okay.
Yeah.
And I'm gonna ask that I know this is a passionate thing, but I'm getting overwhelmed by the amount of people talking over each other. And when I get overwhelmed, I get crazy. Okay, I know you guys know it. I'm just gonna be blunt. So let's dial it back a little bit because I'm going to get overwhelmed, okay, as we're trying to get through this. Okay, so this is what we have for this last chunk here. Is there anything else in this section? Nope, that's good. Anybody online? Michelle, do you have any other tweaks you would like to recommend?
Nothing for this section, no. I have some for the, oh yeah, I'm sorry, for the whole 0300. Do you want to wait till you get to it though?
Yeah, yep, we'll just go chunk by chunk here, and if you have something, go ahead and throw that hand up. Okay, so going on to subpart 2, we have the pre-service advisory committee. This is going to be new to this group. I know I sent it out beforehand, but this is new because after the focus groups and stuff, there was definitely a lot of concern and requests to really flush this out before. It was just more so a one-sentence reference. And people really expressed that they want to be involved in this process, so we flushed this out. So we have the pre-service advisory committee provide support to the board and aids in the development of program learning objectives and categories. Both the board and the pre-service advisory committee reserve the right to consult with outside individuals who have specialized training and expertise in topics covered by the pre-service program. So that means that this group then could consult with, if they know an attorney, somebody on the thing, and they have a lot of knowledge in a certain place, they could bring that attorney, and this group could, when they meet, and say, hey, can you tell us more about this? We think maybe some updates need to be made. So that's what that means. So then we said that the PAC has minimally the following members. So we have 2 peace officer pre-service program directors.
Can I make a comment on that one?
Yes.
Could we make sure that one of them is a director of a psychomotor skills program?
Yes.
At least one of them, I should say.
We intend to allow or designate for these categories. That was my other question.
No, that's probably not a bad idea.
Because like, I'm thinking metro sheriffs.
Yep.
The sheriffs themselves may not be the best people to do it. Commander gets.
Say it so. Yeah, I think we could add or designate to a lot of these.
Actually, Alicia, could we put at least one a director, because it could be both of them, but thank you. That was my comment in that area.
And when will this committee convene, and will there be any parameters? Like, say, if you're on the rules making committee, can you apply for this one?
To be determined, and
Sub B.
let's get through this first, okay? I think some of those questions are going to be answered, Gay, as we work through this. Okay, so then 2 chiefs of police, one from the metro area, one from greater Minnesota. I know there was a sidebar conversation over here. I did not catch any of it.
Sorry. Yeah, we did it
So-
again, didn't we?
Yeah,
Or designate, or both of those.
I think for the
I'm
idea
gonna just say that
of, or designee could be used for 1, 2,
8.
3, and 8. Yeah.
I'm not sure about 1.
Not in one.
I don't think 1.
not one.
I didn't want to cut them out. I don't know how.
Yeah.
I know how the other 3 are.
I think that's a critical enough piece that it should be.
Okay, so just 1 and 2 with or a designee.
No, 2 and 3.
Yeah, sorry, 2 and 3.
Yep.
Okay.
And 8. And then 8.
Would a county attorney's designee be just one of their attorney staff?
Yeah, the attorney.
And do we need to clarify that so we're not getting a paralegal sent, or would a paralegal have the knowledge?
I can't think of any paralegal that would, from a training perspective.
So designee is safe, somebody would be,
Yeah.
they should not be sending paralegals, you would think?
I mean, if you want to be very clear, 2 county attorneys or a designated assistant county attorney, if you really want to keep it tight.
Or you could just say, or an attorney designee.
So you want an assistant county attorney.
I think, I mean, to a certain extent, if the county attorney's association or the county attorneys decide they're just gonna send a paralegal, then I guess they're not that terribly interested in being involved in the process. And I don't see that.
Instead of, I'm sorry, instead of assistants, it should say assistant with a T at the end. Assistant
you.
county attorney.
I'm just gonna ask my colleagues a question. Is there certifications that we want to have designated, like a certified defensive instructor?
I would think that would be good, yes.
Okay.
Let's stop back at 4 because we skipped over it.
Oh,
So we have, no, it's okay. We have 2 peace officers currently designated as a field training officer or a field training officer supervisor, one from the Metro, and one from Greater Minnesota. Then we have 1 you want certified.
Yeah, I believe we want certified on 5, 6, and 7.
Go ahead, Eric.
My only question about that is because infamously Minnesota does not have an instructor certification, which a lot of states do. What does that mean? Certified by whom?
To me, is that they've taken a firearms instructor class.
Yeah, I understand what it means.
Yeah.
I'm just saying,
It's
we
not-
have no requirement that anybody be certified in this state to be an instructor. That's my only concern with that. We should, I mean, yeah, you're preaching to the choir, I agree. We should. But the current rule says when you go to instructors is that they have to have training in the subject area or some garbage like that, which is,
Yeah.
I get it. We say certified, it should mean something.
Well,
and I
actually,
don't know what it
so-
means.
Is it a national certification? Who recognizes it? I'm sorry. Nothing? Then I suppose we can't put it in there.
Yeah, I think, I understand that as well,
Yeah.
but, okay, I'm the chief of police, say, all right, I certify you, there, now it's certified, so. Because since it has no legal recognition of meaning in the state, I think the intent makes sense, but I don't know that you want to add it.
Adam?
I was just gonna add, at least for our department, they have to be certified in like our admin approved DT program or firearms program that we kind of subscribe to, but that's different for each department, you know? So I guess I couldn't attest that every department has certified their instructors, but from our perspective, we do.
Wish we did.
Speaking for Hennepin, we do not.
Okay.
Yeah.
Thanks, Dan.
Well, thank you for indulging the sidebar conversation. I just want to make sure that we have the right language in there.
So we have 1 defensive tactics instructor, 1 firearms instructor, 1 emergency vehicle operations instructor, 2 now county attorneys or an assistant county attorney designee, 1 from the Metro and 1 from Greater, 1 victims' rights advocate, 1 mental health professional, and 2 community organization representatives. That's what we have. Good? Solid? Okay, so then, oh,
Can I
yeah.
just- Community organization, I think we know what we mean when we write that, but it is a bit vague, right?
yeah, the idea is that this is going to be specifically one of the legislative community organizations, so the,
We
I
should
think
probably,
there's a Latino group, yeah, and I guess my other question, now that you brought that up, that I do have is I don't know if that would be, okay, so there's a lot of members on here. There's technically 4 groups.
Yeah.
If we do 4, I think when I get the math, it's 20 people in this group, and that's a lot. So I guess my question then for the group is, do we just delete 11, which I get sounds bad, but then this group can reach out to the community organization leaders because they have the right to do so. And they can have them come in and say, hey, these are the adjustments we're thinking about doing as a community leader. What do you think? Can you take this back to your group, get some feedback, bring it back? I'm wondering if that would be a better use of everybody's time, especially if you're dealing with technical stuff, but then maybe the same could be said for the victims' right advocates and the mental health professionals. But I'm just wondering if reserving the community organization representatives, taking them off as an explicit member, but then like the PAC can then reach out to those groups and solicit their opinions when it's, you know, an appropriate time to do so. I'm wondering if that would just be a better use of those individuals' times, because I also believe the community organization leaders of those four groups, aren't they volunteer or
Well,
not paid?
yeah, this gets us into the trick bag, and Michelle, we see you on there. There are 4 established ethnic councils by the state. So if we set ethnic councils, then obviously all 4 want to be, and then we get to the numbers issues. So that's why I generically left it as community, but I'm leaning, at least personally, I'm leaning more towards what Alicia was saying, just leave it off and let that group involve the community as necessary, depending on the topic.
Go ahead, Michelle.
My concern by taking it off is, I think you could, you know, make it 1 or something like that. But my concern about taking it off is it's really easy to say people can reach out if they see a need. But I think that people get busy and they don't see a need. And so I do think, you know, that having some community involvement on this, you know, whatever that looks like, on this working group is pretty important, because it lends the kind of like people in the street perspective to, you know, the training that law enforcement officers have. And when I am out in the community talking to people about, like, what do you want to see happen to improve policing? Everybody says training, training, training. I don't personally think that's the magic bullet, but that's what a lot of people do say. And so I think having some mechanism for community involvement, formal community involvement, is still important.
Well, let me ask, what do they, is this political window dressing, or are they intended to be substantive? If they're intended to be substantive, I get why you want mental health people and practitioners who are, you know, when I look at their mission, the things like advise the board of pertinent changes of case law, industry standards, and best practices. I just don't see, most of the time, community organizations really would have any knowledge of that information.
Well, with due respect, I represent a community organization, and I think I have been at least minimally helpful on this committee. And by the word is ethnic, and I don't think it needs to come from those councils, because again, you know, I'm not part of that or whatever, but I would hope that, you know, people that have interest in this would be welcome at this table and would have some formal engagement with this table. But, you know, that's just my particular position.
Vince?
Yes, my concern with leaving it on is I don't feel that outstate Minnesota is represented with these groups. That's my thought on it.
Elliot?
I just wanted to agree with Michelle. I think it's pretty important to leave them on. I don't know if they need to be part of the ethnic councils or not, but I do think community brings in expertise that is the community. So that's what I think it's important.
So could we tweak it like this and do and minimally? So if the 4 groups want to, then I guess we get up to 20, but minimally 2 community organization representatives from at least 2 of the 4 ethnic councils.
Why don't we
Could it just be like one-
format of 1 from the metro and 1 from non-metro?
I was gonna say, could it just be 2 public members? Because that's what they do for like state councils and like, think about the post board, right? You have a public member. Could we not just have, there needs to be 2 public members on here, and then people would apply and
I'm a public member on the state board.
that's what I mean, you know, so people would apply to it and you could get real diverse representation, because people could be coming from all sorts of organizations. And
2 public members, 1 from the metro area and 1 from greater Minnesota.
yeah, I think that would be great.
Okay, reactions to that suggestion? Michelle?
I can live with that. I think that's good. I just do want to see some engagement with the public on this, and just knowing how important this is to people in the community.
Right. Elliot, or could you live with this?
Yeah, that's fine.
All right, so then moving into B, the PAC must conduct an annual review of the POP and provide a report to the board subcommittee on training by December 1 of each year. Provide program recommendations to the board as needed and as a result of the annual review. Advise the board of pertinent changes in case law, industry standards, and best practices that affect the program, and complete any other tasks requested by the board within the purview of the committee. So the purpose was with B then was to make sure that this group was intentional and that they were meeting throughout the year, and that, because I feel like sometimes we create groups, not necessarily the post board, but just in general, government creates groups and then nothing productive is done with them. So we wanted to prevent that from happening. So Pat, you have your hand up.
I'm wondering if we need a point on here about a length of term of service, like the members will serve for 2 years or 3 years, or if once they're appointed, they're there until they die. Which happens sometimes, just pretty cool. Well, it is pretty cruel, but you know, until they retire, I mean, is the point that we'd like to change over every couple of years or give other people
Right.
opportunities to fill positions? And if so, it'd be nice to know a cycle so that if Tom is one of the reps and he's like, I've just got to be done. I want someone else to come take it. We know that in 3 years, you can put in to be on the board or on the committee. That's
That's a
all.
good point.
That's my concern.
If there were to be a term, how long is 3 years? And then you can reapply, of course, because that's what our board members do. I think if it's X amount of years, they can reapply
They're 4-year terms.
4 year.
I don't, if you want to align it 4 years and make sure that would be fine with me. I'm just like some sort of term. And then we probably also need to put a comment on there if people can serve on multiple committees for the post board. So like if you want to be on the advisory rules committee, can you also be on the pre-service? I'm just saying, sometimes we have multiple committees going at once.
So
I don't know.
I
if
know
that's
people like
important.
to see things written, but my general generic answer to that would be these people are going to be, right, you're like, there's probably like, so with our advisory committee, the membership or the process for that isn't dictated in rule, but we do an application. All of your applications then go to the rules committee and then they make their selections as to who's going to serve. And we change the advisory rules committee essentially with every rules package because we want to make sure that the people contributing are essentially more so subject matter experts, right? So this wouldn't necessarily oscillate like we do, but it would be a similar process where we would put out an application, people would apply, the training committee then would select the membership based on these criteria. And then since this is a standing committee, you would just be on it until there is a term limit. So that I can definitely see that as something we should put in. But since like technically this committee is more so ad hoc, it's done as needed with individuals on an as need basis. I would see that that's going to be how that more so works. Yeah, Eric.
And I'm fine with that.
Okay.
I just brought it up because it was a question.
To that point, Rick, just asking kind of your opinion. When we create, so what we're doing is we're using Google to create and basically an advisory committee to the board. Like when the Public Safety Advisory Council was built, there was statutory reference, it'll be handled under 15.59, blah, 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 which of course we don't want to get that formal, but are we okay just saying, yeah, here's a committee that's just going to give the board advice? Do we have to, I think we should put some sort of, or just let it happen organically.
I think it's a business question. Technically, you wouldn't even have to, you could have this exact committee without even addressing it. Or it always has that authority. There's no rule right now that put any of us in this rule.
Okay.
You
Chose to do that.
You chose to do that for lots of hopefully good reasons.
Yep.
So if you wanted to delete this entire section from rule and do exactly the same thing, nothing would stop you from doing it. Because it is an advisory body, which by definition means you accept the advice or don't.
Right.
So I don't know that you need term, the post board people do have a defined term, right? Because it is a quasi legislative body. Just like what I said on the private detective and security board, we are quasi legislative, quasi judicial body.
Yep.
We have rules, we take licenses, but this advisory committee is not. I think this is a good idea. Go sit in court. Yeah. So I think, Eric, it is whatever the board as as to its
So we could,
credibility, for lack of a better word.
so we could theoretically, not theoretically, we could just adopt like an internal process and not even articulate it.
Wouldn't even need, you wanted to shorten the rules, eliminate everything, any reference to the advisory committee. This, the board has overall.
That captures my thought just fine.
Okay. Caveat, I might tweak that a little further and clean it up, but that'll be the gist.
I like the idea.
So anything else on that part before we move on to subpart 3? Then we have, this is from the old rule, we just pulled it over, and this was a change this morning. So all certified schools shall comply with the minimum requirements of subpart 1 and shall furnish resources to approve the board to verify the provisions of subpart 1. Nothing in parts 01 to 18 precludes any certified school from enacting rules which establish standards of training above the minimum requirements in subpart 1. So that's in rule currently, we just threw it back in.
I'm not sure that, I absolutely think it's a good idea, but I think there might be a better rule or a better phrase than enacting rules. Because when we're dealing with rules, somebody's going to say, well, when these schools go through the rulemaking process, they're not from establishing curricula
standards.
or establishing standards or.
In other words, get rid of the enacting rules and just say any certified school from establishing standards of training above the minimum.
Or something like that. I just think enacting rules
That is kind of weird.
is a weird way to phrase it.
That makes sense.
So get rid of enacting
Yeah,
rules.
and just say from, then change established to establishing.
Yeah, just make that establishing. There you go.
Subpart 3, okay? And subpart 4, compliance reviews. Certified school, oh my gosh, a school certified and approved by the board to provide the police officer training program shall comply with the requirements prescribed in 03 and 04. Certified school must fully cooperate with scheduled and or random compliance reviews by the board. Board reserves the right to conduct a compliance review on certified schools at any time. Certified schools will minimally be subject to a compliance review once every 2 years. The board will review the certified school's training materials, facilities, and or equipment. During review, a certified school must supply any documentation or records kept on their program or the participants as permitted by law to the board as requested.
I have a question.
Yeah.
Just for the sake of being parallel, so the certification process is every 3 years for certified schools, and then there's a compliance review every 2 years. Is that purposeful, or should we make it align?
That was intentional because during your research, you'll have, like, I'm not
You have a
100%
site
sure.
visit,
But yeah, but Rob collects all of that stuff and does a recertification
Yep.
process. This is more so checking for compliance in between those 3 years. So this is not necessarily directed at you guys, but it's saying that us as posts, this is now the standard we're holding ourselves to, is that we're gonna do additional checks, not necessarily to jam people up, but if schools need help, if there's a director that maybe needs guidance or assistance with an issue, we're doing more frequent check-ins to make sure that we're also helping you guys be successful. So this is more so to keep us on top of our game. Anything else with this section? No? Okay. Then moving on to subpart 5.
It's basically the old rule language just brought back in.
Okay. Yep, so we have general applicant enrollment requirements for all components. certified school shall develop standards for admission to the professional peace officer education course. The standards must measure the student's likelihood of successful completion of the program.
Now, do we need to rename that
Yeah, I don't know
professional
why this
peace
is-
officer? Change the term to,
Yeah, we'll have to change that. I don't know why. This is gonna be cut.
That's gonna be out of there. Okay.
what,
Well, a serious threat, so you can be a marginal threat? How did that get in there?
well, this was the existing rule.
Okay,
This is in the existing rule. Now, if we want to change it, then now's the
Yeah.
chance to do it, but that's directly from the existing rule as it reads.
because this is getting to all components. So those schools that do the academic part, are you checking for this 07 for the academic piece? Okay, so we can, whoops, daisies, leave that, but this portion, I mean, people that are a marginal threat, as this would suggest, can get into the program. So can we just cut this?
I think you
Should
have
it
to,
just be threat? Just get rid
yeah,
of
I think we
serious.
need to either leave serious or just go to threat, but I would check with our psychological professionals on that one.
I think if you're a threat to the health and safety of the cell.
Suggest dropping serious and then just maybe talk to the psychs. If they can make that assessment.
Is this also the spot to add in the statute about racial profiling? We have to, there's a specific statute that they will not engage in racial profiling. I pulled it out before and and people sometimes forget it because it's not listed here.
That directors can't engage in?
No, the student, that they have to be evaluated, that they will not engage in racial profiling.
So
It's
that's
actually a
in, so
statute.
that's in the psych portion. For the minimum selection standards, I think, and I think that is part of what we had covered.
Okay, just making
So,
sure.
Yeah, so then that should be covered through the psych that the schools do. When you get the report back from the psychologist is supposed to make sure that there's nothing glaring that suggests that they are in violation of the minimum selection standards.
Oh, actually, that's not, we may have to tweak clause C then,
Yeah,
because it talks about only about whether they are fit to enter the program and to the point. That's different than the.
yeah, so I think what we're gonna do, because I missed that this was a complete copy and paste, you guys, so I'm just gonna highlight this for myself to go in and tweak this so it's consistent with the current language that we have in subpart 6, which we spent a lot of time on.
That's my bad.
No, that's, I didn't catch that, so that's my fault. So I will tweak that and I will send out, a revised copy by the end of today, and then you guys can take a look at that chunk and let me know if you see anything glaring that needs to be adjusted there.
Another possible replacement to the word serious under P1. You see this, for example, in federal law for firearms and domestic violence. The term is poses a credible threat. I'll start to get into terms of art, so I'm not advocating for anybody, but I do know that's a term that's built into some statutes.
So then with that, subpart 5 covers the enrollment requirements for any component or both components. Subpart 6 now was tweaked to just speak to the psychomotor skills component enrollment requirements. The requirements are the same as what they were that this group drafted, but we tweaked the initial paragraph to say to enroll in the psychomotor skills component of the POP, individuals must complete the board's application and satisfy the requirements of this subpart. The program director of the certified school delivering the psychomotor skills component is responsible for ensuring applicants meet the requirements described in this subpart before they enroll in the psychomotor skills component of the program.
Be sure that we're not running into a fall of discrimination laws, even by saying if you've been convicted of a disqualifying crime, you can't attend the academic portion.
This is the skills
This
portion.
is skills.
No, I'm back to, I thought maybe admitted, I get that for subpart 6, but I'm back still with subpart 5.
That's in existence right now.
I know,
They've been
but
doing
I know, but that's only be,
No,
is that
that's-
only because no one's ever called them out on it? I'm a
I'd
convicted,
fight that fight.
I was convicted of a misdemeanor crime of domestic violence, and I want to attend section 1 and section 2. Get my associate of arts degree, but
Well, I
that's
think,
part of the program.
yeah, I think to Gay's comment earlier, they then take them out of what is the official PPA and throw it in the AA. That's what I heard.
Yeah,
Yeah. I think it's an interesting question though, because if the academic component is truly now defined as only sections 1 and 2, you can make the case that like, you don't need to run a background check on a student
Yeah.
for them to take those classes.
I think I will probably remove that and just
Yeah.
say 1 and 2 are gonna be different, but let's, like I said, let's skip over that teal portion for now. I'll make some tweaks. If we have to have another meeting to flush it out more, if my tweaks are unsatisfactory, let me know and we'll take care of it. I just don't wanna spend the next 30 minutes altering this part. We have a lot to touch base on yet.
In 6 there, you indicate the board's application. So is there gonna be an application done by the post
Yeah.
board and also the providers?
We would provide
A standard?
Yes.
standard
application?
application.
Yes.
Okay, that's what I
Got
got.
it.
All right, thank you.
Okay.
Thank you. Okay, so then A, B, C, D, E, F are all the same that this group did. And then it just says at the bottom, applicants attending multiple certified schools to complete this, the POP must complete the necessary steps to allow certified schools to share enrollment data and information. So if you have a primary and a secondary, they need to sign whatever documents you guys need to allow you guys to communicate together. So then 7, certified schools responsibilities. A is the same. B is the same. C is just, it is the responsibility of the certified school and director offering the psychomotor skills component to ensure POP applicants satisfy enrollment requirements described in subpart 6. Primary and secondary schools shall communicate with one another if enrollment requirements are found not to be satisfactorily met prior to or while a student is enrolled in the program. Yeah, I think that hopefully is self-explanatory.
Back to 6, so very quickly, the last line must complete the necessary steps. Do we feel it would be appropriate or redundant to add and sign any required releases? Because this does have major data practices components. And
Because it used to say the necessary paperwork, so we just put steps in there. So paperwork, that's kind of an antiquated term.
Or maybe releases.
The necessary releases.
yeah, releases and steps, because there's clearly going to be more payment of fees and all that.
And instructor requirements. These are largely the same. There just was a tweak here on B, to say that full-time instructors must complete an adult learning instructor development or curriculum development course prior to or within the first 2 years. While this does not apply to adjunct instructors. Was the change there? Yeah, James?
So I have a question on the instructor requirements. I know there's been a lot of back and forth on this, so maybe I'm just not following clearly, but so it says all instructors, including adjuncts, who teach in the certified schools peace officer pre-service program. So that's categories 1, 2, 3, and 4, correct?
Yes.
So are we saying that in order to teach categories 1 and 2, you have to have 3 years of full-time work experience in law enforcement or criminal justice? Because I don't know if that would apply to every faculty member that teaches in those programs. Maybe I'm wrong, but are we okay with that? I don't know. I'm asking. I'm thinking in a 4-year college, introduction to criminal justice, for instance, is that going to be necessarily taught? What if it's taught by a PhD criminologist and it doesn't have 3 years? work experience.
Constitutional law expert.
Right, exactly.
Lawyer, law school.
I don't know, I'm just saying, I can 100% see where all this needs to apply in the event of psychomotor skills.
We're talking about two, right, James?
I'm in subpart eight, yes, A2.
So then in law enforcement or a criminal justice related field, does that not cover it?
Well, I'm just saying, for the universities that have full-time faculty members, do they need to have had work experience in the field? Because I mean, most of our faculty do. Like, I'm speaking more on behalf of like all universities here, not my own. We would qualify. We're good. But I'm just saying, like, so if you're somebody that's come out of graduate school and you have been hired as a full-time faculty member at a university's program, you don't necessarily have 3 years of full-time work experience in the criminal justice field.
That's a good argument. I, for one, would argue that you should, but you're right. You could
No,
argue it
right,
either way.
and that's,
So-
I just want to make sure we're clear about that before we make it rule, and then we look back 3 years from now and be like, shit, I can't find anyone to teach this class. That's all I'm saying.
This
Yeah.
was the language that this group approved.
Yeah.
And again, things
Now
have
the
moved,
context
right?
needs to
But the context changed it because I look at this and I'm like, for skills, 100%, sign me up. But for, I don't know, to teach history of policing, like, I don't know, is that
Argue yes.
right?
It's a philosophical
Yeah.
decision, is what it is.
Okay, so then let me use my example of constitutional law. Again, Alan Dershowitz was willing to come and be a faculty.
Well, that's a bad example.
Well, yeah.
Can you pick some other one?
But he's got 3 years of experience in the criminal justice field, you would say, right?
Well, we don't define what that is.
Yeah,
He's done some, he represented O.J. Simpson. Does that give him- But does that mean he's a defense attorney?
yeah.
Does that qualify as, yeah, somebody like me
Arguably.
with, as a prosecutor for, since the Roosevelt administration, yeah. But there could be, or I'm thinking, or psychologists. We may have, a PhD psychologist who's going to talk about mental, also maybe a faculty member, and has got no criminal justice experience, maybe they testified once at a Rule 20. But that certainly, they could be, we don't have a lot of Loring McAllisters out there who are psychologists.
That's sort of what I was really getting at. It's like, you're teaching a crisis intervention class, for instance, and it's taught by a PhD level psychologist, but they're not a licensed clinical psychologist. They've not actually practiced, but they are a researcher and an expert in that field. They technically wouldn't qualify, I think you would argue.
Actually,
Well, wouldn't researching be considered work? I feel like that's a lot of work. So you're
But not
working.
by this, I don't think.
Well,
Yeah.
Well,
Well, for instance, I had 20 years of research experience, but it wasn't enough for the post board for me to be a PPOE coordinator. So to your question, the answer would be
Yeah.
no.
No.
Darn you in your work.
I know,
Isn't
right?
enough.
It wasn't enough.
Okay.
Because I hadn't actually been a serving police officer, or I hadn't worked like as a full-time probation officer or something like that. I'd been consulting in all these agencies for decades, but that wasn't enough according to the post board to be a PPOE coordinator.
Right.
So if you apply that same standard here, then I would say that several faculty members are probably not going to be qualified to teach the classes that they currently teach. So I'm just saying it.
Yeah,
just saying
no, I
it.
hear you.
I think this group would have to provide its opinion on philosophically, and again, the board will have to decide if they want to be that stringent or if they want to take your argument, I guess. So, because we've had our discussion before and we kind of
Yeah.
ended up at this point, so. We don't have a dog in the fight per se, other than,
I mean, I think it's probably fine,
So, okay.
but
So let's just take a survey of the room quick. Who, raise your hand if you want them or think that the work experience part should stay. You have to have work experience in the field to teach it, 1 through 4.
I think it should stay, but I think it needs to be broader.
Okay,
Say,
Well, let's
in,
just-
in a criminal justice related field or the field in which they are instructed. So if I've got somebody with that 20-year psychologist, they meet the criteria. They never,
okay,
so I think, or using, again, I don't plan on doing any teaching with this stuff, but somebody like me, who doesn't have a prosecution background, but maybe a constitutional scholar, was a law professor, they would then meet that criteria.
Vince, I'll get to you in 1 second if you have a comment, but raise your hand online if you want the full-time work experience requirement to stay. So, ready, set, go. Vince wants it to stay. Anybody else?
Can we vote on the modification that was just suggested?
Not yet.
Okay.
It's like one thing at a time. Vince, did you have a comment?
No, I was just raising my hand because I thought I was supposed to, for if I wanted it to stay.
Okay, perfect. Thank you. Okay, so then going back to the modification, Rick, what was the suggestion again?
It would be, or a criminal justice field, or the field in which they are the instructor.
Unless I'm misunderstanding, I don't know that quite broadens it. But I have a note for myself. If it's okay with you guys, I'll write an alternative option. I'll let the rules committee know that there was only 2 out of like the 12 of us here today that wanted this requirement to stay, and I'll pitch them alternative language that opens that door a little bit further, especially for the 1 and 2 side of things. Because I'm gonna guess that I'm gonna have to parse this out and make it specifically for psychomotor skills component instructors will have blah, and that's gonna be more than what I have to do right now.
I catch my pitching, so I can help you with that.
So anything else unrelated to A2 in this section?
I was gonna say on B, since you're now putting an adjunct instructor definition in, you could probably just take off that does not apply to the adjunct instructors. Because it very clearly says full-time instructors.
Okay, very good. Thank you. Anything else? Okay, so then moving on to 9, director requirements. Oh, I believe these are gonna be exactly the same. The director requirements are not to be confused with like department chair requirements. Your department chair doesn't necessarily have to be your program director. And these are copy pasted from what this group did. Yes.
I do just have one question. Under A5, it looks like they have to do adult learning within being 2 years of being employed as the director,
Yeah.
not just within 2 years of being employed with the organization.
Wait, read.
Yeah.
I would suggest it should be within being employed by the organization.
Okay.
Because otherwise, every time we switch directors, they would have to redo it. Like, so if I switch to a new director next year and they did their certification like 8 years ago, then they would have to redo it again the way it's written.
Well, it does say prior to or within.
Mhm.
So that,
Prior to.
yeah, so that actually,
Right.
you're still covered. But it's saying if you've never had it, within 2 years, you need to have it.
That's why.
Yeah, so I think we leave it.
Okay, that's fine then. Okay.
Then safety policies required, that is the same.
Hey.
Oh, go ahead.
Quick, on B, you need to change that from PPOE to,
Oh, yep.
On B.
I'll go back up to 9.
yeah, sorry, just too quick for me.
Subpart 9,
About
B,
safety policy.
B still says PPOE.
Oh, that's supposed to, because it says coordinators from PPOE programs who are
Oh,
appointed
that's right.
before, so that's the grandfather clause, yeah.
All right.
Michelle,
Okay, so on 10E, I don't know, maybe I'm going too fast, but on 10E, it says directing instructors, or relates to the safety stuff. I take out the directing instructors, just say guidelines, change it to guidelines to reduce instructional pace.
Okay.
Because it's like the language now doesn't make any sense. Okay, there you go.
Okay.
Little wordsmith thing.
Yeah, thank you, Michelle.
On that same point.
Yep.
Do we need the word waves? Does it have to be a heat wave or can it just be a hot day?
Oh, but extreme heat.
Yeah, something like that. There you go. That's what I was getting at. Yeah, during extreme heat or cold or the reverse.
Yeah, there you go. Yeah, during extreme heat or cold.
Or other adverse climatic environmental conditions.
Perfect. Because wave implies
Yep.
only after 4 days can we implement this, you know?
You're gonna like the heat.
Yeah, so you could have extreme heat or cold, put an or after heat. Take the comma out and put an or there instead
Forget
on
atmosphere.
letter E.
Extreme heat, cold, or other. Where are you talking, Michelle?
In
Oh,
that
I
same,
was just saying extreme heat or cold, but I think it's fine. If during extreme heat, cold, or other, I think it's fine. It's fine.
Okay. Okay.
Should that, wait, guidelines directing instructors, is
Got
that
rid of
two?
Yep.
took it out.
Okay, but then, if we only use the reduce, what about reduce or modify? Maybe I simply switch it to a classroom component for the day.
Yeah, that's true, actually. So maybe the word is modify, not reduce. Yeah.
You just want modified
To
period?
modify, yeah.
Yeah.
Well, you could do reduce or modify.
Doing all right?
I'm gonna cover it all. Okay, so then with those changes,
Can I make a comment on the last one?
yeah, sorry, let me.
On the subdivision 11? Or subpart 11, I'm sorry.
No, it's okay.
Yeah, I have a change for 11 also.
Instead of written safety policies, it should be published safety
Thank you.
policies. Thank you.
Go ahead, Michelle.
And then it says in there, required in subpart 8, and that needs to say change to subpart 10.
Thank you.
It's just a typo. Because it's referencing the one above it.
Okay, so then, got that. So then temperature check. We have consensus on this. Yes, anybody online, raise your hand if you hate it, won't consent, give consensus. Nothing, okay, perfect.
Is the safety briefing internal or is it with the students?
Under,
Subpart of new 11. Where it
The
says
new
instructors
11.
shall review these policies in the form of a safety briefing.
It's with the students.
Specify that.
shall review, okay, in the form of a safety briefing with participants
Yeah, that's better. 'Cause
prior
I like
to
what
any
you said.
psychomotor skill. Okay, got it. Sure, Tracy would thank you.
Yeah.
Okay, perfect. So then. All right, 04 and the certification of schools. I'm probably like 50-50 on changes. Okay, so 04 subpart 1, application. This is gonna be the same. Other than just changing it to the POP. So you need your proof of accreditation, signed acknowledgement by the school's president, a director appointee and a list of instructors, and then a strategic plan and a detailed list of the facilities, equipment, and locations the school intends to use, to deliver the program and its learning objectives. Anything on that one?
just a clarification, the school's president, are we talking all the way to the university's president or?
I believe so.
Okay,
Could
Yeah.
we put or their designee on there?
Sure.
I was
Is
gonna
that how
say,
it's usually?
that's gonna be
Yes.
a bureaucratic nightmare.
Yeah.
You're gonna do this, Mr. President?
Yeah.
Because I just wondered, because I think in the previous ones, it could be like a dean or a department chair could do it, right? So,
It just said the school's delegate or something like that.
yeah,
But, yeah, it was a word that I didn't know what it meant, so I just went with school's president. Yeah.
yeah, that, for universities, that's a recipe for it never getting it done.
Exactly.
Oh, okay.
In like 8 years, maybe.
Yeah.
Okay. So then subpart 2, minimum requirements, deliver the POP, the school must deliver the board of learning objectives.
Actually,
Put 2 boards in there.
sorry to hark on this,
Go ahead.
but I've just thought, for the application, surely the person that is the one that really needs to sign off on this is the director, like the PPOE coordinator, or what we're now calling, whatever we're now calling them.
Yeah, but I think this is more so getting at that they want also some kind of affirmation from the school that the school itself will also hold its staff and director accountable
Oh, I see.
to the requirements set by the board. Yeah, so it's also
Okay.
like making your boss's boss aware that, hey, like this isn't
All
just a willy-nilly program, there are rules you have to follow. Yeah.
Okay,
Deliver the board approved learning objectives and then possess or have access to the appropriate physical facilities and the necessary equipment for training, including but not limited to classrooms, a firearms range, space suitable and safe for defensive tactics training and an emergency vehicle operations track. As applicable, bold, subpart 3, secondary training facilities. Certified schools may use secondary training facilities or locations for firearms and emergency vehicle operations training if, scrolling down, the use of a secondary training location was disclosed to the board and approved during the initial application or reapplication process, and board staff have access to the secondary training facility or facilities to conduct inspections and compliance reviews as described in 6700-0300. Pat,
So the way this reads is the only certified schools are the ones that offer all 4 categories.
why does it read that way?
Because for those that are only offering the academic portion, why would we have to have access to vehicle operations track or secondary locations and ranges?
It's tactics training.
This is as applicable.
But it says possess or have access to appropriate physical facilities as applicable, but you don't parse out anything about the difference between academic and psychomotor skills. These are the minimum requirements for certification. Okay.
But doesn't, as applicable, it wouldn't be applicable to you.
But if this is the minimum requirements for certification, we don't,
Certification, yeah.
yeah, the certification would assume that we're doing all the categories then.
yeah, I feel like you need almost like a
Parse it out.
two-prong approach here, which kind of like,
Yeah.
if you are applying to be an academic provider,
If you're.
you need this. And if you are applying to be a psychomotor skills provider, you need, and then that's where you put in your fire range and space suitable for defensive tactics and all that type of stuff.
But for academic schools, would it be, if I were to separate this out, academic schools need to do the yellow? And then it would be and skill schools then and need this part here.
Yeah, I think that's what it would be.
Or could you just simply explain the as applicable to the school certification? Because if you're not certified to do 3 and 4, that by definitions, because as soon as you say as applicable, there's, but it's always applicable to what? If you simply say as applicable to the school certification, that seems to be to get you for the pure academics, that it's crystal clear. You don't have to worry about that.
So just add as applicable to the school certification. Would that
That gets
make you happy?
That would, as
Comfortable?
long as it's clear that if someone's applying to just be an academic school, they're not going to be expected to have access to this.
Yeah, and I think certification might not be the right word for that reason, because it's It's more like your school's classification, because this particular subpart at the top is called minimum requirements for certification.
Right.
So it's more about what are you classifying to be? Are you 1 and 2, 3 and 4, or 1, 2, 3, and 4? Sort of 3 different approaches going on there.
And maybe as applicable to school certification.
And the components they teach.
I think what we're running into here is exactly what we had to do with 0300, which was to bifurcate the two.
Yeah.
And I think I think there's probably more, there's gonna be other places here where we need to do exactly that, so. Maybe this is one of those, Alicia, for sake of time purposes. Let's go through it, get these suggestions, and then we bifurcate it kind of the way we did with the other one, with 0300, then we'll present it. Oh. That was extremely focused on 0300, trying to separate the two, then this probably needs some of that.
Can I give you a compliment, Alicia?
Yeah.
I like how you define the secondary training facilities. That was very clear, very well done.
Well, thank you, Matt.
Well, we're harping on you so much, I wanted to just give you a compliment.
Well, thank you.
Sure.
Right, so then application review. The board shall review a school's application and supporting documents to ensure the school has a provided proof of compliance with the program and has the appropriate equipment and facilities to offer the program. I will tweak that to be as certified. That out a little better. Conduct a full inspection of the school's amenities, including but not limited to the school's training facilities and equipment. The board will not approve any school for certification prior to the full inspection being completed. So other than me trying to make that clear between the types, I guess, of schools that we have now, is that good? I think that's exactly as what we had before. Recertification.
When you write the board, does that contemplate the entire board packing up and actually the board doing it, or?
No, the board can delegate its authority, so it's gonna be Rob. Rob's gonna get marching orders.
We make that reference throughout, where, and the
I've
board
seen that.
delegates.
It's just
the word, yeah.
the question I was gonna ask.
No, yeah.
Recertification, schools have to recertify once every 3 years. Recertification will be granted by the board if the school is compliant with the provisions described in Rule 0300 and 0400. At their discretion, the board may require a school to recertify more than once every 3 years. If the board determines a school needs to recertify prior to 3-year expiration, the board will provide a school reasonable notice. I think that's what we had before. And again, that's more so getting at the triple secret probation for issues that need to be rectified, if any. 6, certified school requirements post-certification. Certified schools must comply with the requirements listed in this subpart. A school's failure to comply with the requirements listed in items A through F may result in disciplinary action by the board against the certified school or its director. I believe these should be the same. Maybe one tweak at the end. So provide instruction according to 0300 subpart 1 for which the school was certified. Provide the board any requested documentation or information that shows the certified school is compliant with this part in Rule 300. Must cooperate with any board review or investigation relative to its certification. D is the same as it is in current rule. Certified schools and staff on E must comply with provisions of 03 to 05. And then certified schools and staff must comply with any order issued by the board. Those are going to be the formal orders, such as cease and desist orders that go through the Administrative Procedures Act. We're looking at Rick.
I do have one question about this, about the, if you go back up, it says, go up a little bit higher. It says something like, may result in disciplinary action under like the beginning part, may result in disciplinary action by the board against the certified school or its director. But when you look down at the discipline, there's no discipline for the director. So I don't know if you want to just take the or the director out of there. Because I'm missing what the discipline would be on the director.
Are you talking right here, Michelle? Because I have on 7, maybe imposed upon a certified school or director by the board include. Is that where you thought it
Right,
was
but it
missing?
says, so a letter of censure would go against the director or against the school?
It could go into either.
Oh, okay. I didn't catch that. To me, it seemed like that would be something against the school, not the director, but it's fine.
Okay. Yeah, 7 is the same, 8's the same. So anything on 0400, or do we have consensus on that?
But with your you were gonna do. some
Yeah, I'll do some modifications, yep. I can send that one out as well. Just write it out to myself. Okay. So then, we are at time. We have 04, 01, 05, and 06. What is the date? And then you guys have your PPOE conference on the 28th, right?
Yes.
Yeah.
Okay.
I mean, to be honest, the changes in those last two that we've not got to today are pretty, I think,
Yeah, they're not crazy. So would it be okay? I guess I'm just throwing it out, rather than a formal meeting, and if you want a formal meeting for 04, 01, and 05, and 06, like, feel free to say, no, I want it. But are you guys okay just looking at those on your own time? And maybe we'll make the 28th, October 28th, the deadline to get me any written suggestions on 04, 01, and 05, and 06. And then based on the written suggestions, if it seems like we need to convene another meeting to hash those out, we can. Is
yeah,
that okay?
I mean, those two documents are like 2 pages total.
Yeah.
They're really short, so.
Yeah, and I don't.
And I
think
didn't
the
see any changes. I
were
wanted in
crazy.
any of them. So yeah,
The
I'm
only
good.
thing we did, that you guys will see that is, it's not super significant, but when we had the academy model, it was you get so many test attempts, then you have to redo the academy. Instead, we bumped it up by 1. So I think it's now 4 test examinations that you get, and then you're just essentially done. That's in line with what other states do. The number of attempts in the rule draft currently is still more than the average most other states give students, or law enforcement hopefuls. So, that's really the only thing that we had to really dive into and make modifications to now within the skills format, since there's not like a formal. Because the issue, we could have said that, we did originally say you need to go back and redo skills, but then somebody brought up a good point. Well, what if the areas you're deficient in on the test are
Academic.
1? Yeah, you're not gonna send somebody to skills for deficiencies in 1. So we just kind of took out that and just said, you have X amount of attempts. If you can't do it by then that's kind of tough. So, all right, so we will make, and I will send out an email reminder, but let's do October 28th, the deadline for any written comments, suggestions, concerns for 04, 01, and 05, and 06. And then after that date, I will touch base as to whether or not it appears that we need to schedule another meeting. But other than that, just keep an eye out for additional written communication from me. The Rules Committee of board members meets tomorrow, so all of this stuff, super fresh, is gonna get whisked off to them tomorrow. And then, yeah, from there, just continue to reach out to me with any questions. Go ahead and share these with any colleagues of yours that you have, and we will go from there.
Nice work, Alicia.
Thank you.
Yeah, well done.
All right, thanks,
Thank you
everybody.
for all
Appreciate
your hard work, everybody.
Thank you.
it.
Yes.
Can I take a picture? Oh, okay.